Welcome to S&C's podcast series, S&C Critical Insights. My name is Jeff Scott. I'm a partner in S&C's litigation group and co-head of our securities litigation practice. I'm joined by my partner, Julia Malkina, who is also co-head of our securities litigation practice and a partner in the firm's Supreme Court and appellate practice. Today, we will discuss the upcoming oral argument in Facebook versus Amalgamated Bank and the important implications for companies' risk disclosures and potential litigation regarding those risk disclosures. Julia, why don't you give our listeners a brief overview of what we will discuss today?
Thanks, Jeff. I'd be happy to. On November 6th, the Supreme Court will hear oral argument in a case called Facebook Inc. versus Amalgamated Bank. And yes, the case dates to before Facebook rebranded as Meta. The issue before the court is whether risk disclosures are false or misleading when they do not disclose that a risk has materialized in the past, and if so, under what circumstances. So we'll first talk a bit about the background on the Facebook versus Amalgamated Bank case, and then summarize the key issues and arguments that the Supreme Court will consider. And finally, we'll discuss the case's possible implications. So let's start with some background. Jeff, what do we need to know to understand the issues in this case?
Of course, Julia. First, I think we need a little bit of the background here on SEC disclosure requirements. In general, under Section 13A of the Securities Exchange Act of 1934, companies of a certain size are required to file annual reports that are known as 10-Ks. They include a section captioned Risk Factors that discusses the material factors that make an investment in the registrant or offering speculative or risky. Julia, can you discuss the requirements of Section 10B?
Absolutely. Fraudulent statements, including in risk factors, are prohibited by Section 10B of the Exchange Act and Rule 10b-5 promulgated thereunder. Section 10b prohibits manipulative or deceptive practices in connection with the purchase or sale of securities. Rule 10b-5, in turn, prohibits making any untrue statements of a material fact or omitting material facts necessary in order to make the statements made in light of the circumstances on which they were made, not misleading. To state a claim under Section 10b and Rule 10b-5, a plaintiff must allege several elements. First, a material misrepresentation or omission by the defendant. Second, scienter. Third, a connection between the misrepresentation or omission and the purchase or sale of a security. Fourth, reliance upon the misrepresentation or omission. Fifth, economic loss. And sixth, loss causation.
Thanks, Julia. As we know, shareholder complaints alleging securities fraud also are subject to additional heightened pleading requirements under the Private Securities Litigation Reform Act, particularly for alleging a material misrepresentation. What's important for our purposes today is the material misrepresentation or omission requirement. The issue here is whether and when it misleads a reasonable investor to disclose as a risk something that has already come to pass. For instance, if a company discloses the risk of various regulatory investigations, is that a misleading disclosure if in fact the company was subject of an ongoing regulatory investigation? Julia, we need a little bit of the background on the Facebook case, why it presents a question regarding risk disclosures, and how it made its way to the Supreme Court?
Certainly. I'll start with some factual background. Beginning in September of 2015, Facebook employees noticed that Cambridge Analytica, a British political consulting firm, was harvesting Facebook user data, both from users engaging with Cambridge Analytica's content and non-consensually from those users' Facebook friends. Cambridge Analytica was using this information to create a database about American voters, and they were providing the data to American political candidates. Cambridge Analytica's actions violated Facebook's terms of use and user data policies. In the risk factors section of its 2016 Form 10-K, Facebook disclosed that third-party misuse of Facebook users' personal data was a risk, stating that any failure to prevent or mitigate security breaches and improper access to or disclosure of our data or misuse of such data, which could harm our business and reputation and diminish our competitive position.
As we now know, Julia, in 2018, the extent of Cambridge Analytica's data breach emerged. Facebook's stock price declined, and its shareholders brought claims against Facebook and its senior executives under Section 10B and Rule 10b-5. They alleged, in essence, that Facebook's risk disclosure was misleading because it disclosed only that the misuse of user data could harm the company if that harm materialized. It did not disclose, however, that Cambridge Analytica had already caused a substantial breach of Facebook users' data. So, Julia, what did the lower courts do with this claim?
The district court dismissed the Section 10B and Rule 10b-5 claims. A divided Ninth Circuit, however, reversed in relevant part. The Ninth Circuit applied its recent precedent in Re Alphabet, which held that falsity allegations were sufficient to survive a motion to dismiss when the complaint plausibly alleged that a company's SEC filings warned that risk could occur when, in fact, the risk had already materialized. Thus, the Ninth Circuit held that Facebook's risk factors were misleading when Facebook was aware that Cambridge Analytica had, in fact, violated Facebook's security terms. The Ninth Circuit concluded that a reasonable investor reading the 10K would have understood risks involving data misuse to be conjectural rather than to have occurred.
Thanks, Julia. There was, of course, a dissent from this element of the Ninth Circuit's decision. The dissenting judge reasoned that Facebook's risk factors merely warned about potential harm to its reputation and business that may occur if the public or government learns about improper access to its data. The risk factors did not represent, even impliedly, that Facebook was free from significant breach at the time of the filing. The dissent pointed out that Facebook did not even know about the harm the data misuse would cause, and a reasonable investor would have read the risk statements to indicate that Facebook was, in fact, already facing heightened risks regarding data breaches.
In the Supreme Court, Facebook argues that a risk disclosure is not misleading because it fails to state that the so-called triggering event had already occurred. Facebook argues that a reasonable investor would understand that risk disclosures are exclusively forward-looking and contain no implied representation about anything that happened or didn't happen in the past. Facebook acknowledges that there may be instances where a reasonable investor would want to know that certain risks the company discloses of had already come to pass, but it argues that labeling such outcomes as risks does not itself imply any representation about whether those events had occurred and is therefore not misleading. Facebook also warns of negative consequences from the Ninth Circuit's rule, saying that stock drops would encourage would-be plaintiffs to scour a company's recent public filings in hopes that the company had vaguely warned of the risk previously and could then be accused of having misled investors in doing so. Now, that doesn't sound good. What do you think of these arguments, Jeff?
There are many aspects of Facebook's arguments that I think are correct under the federal securities laws. One aspect in particular that the Supreme Court might find appealing is the relative ease of applying Facebook's proposed rule. Risk disclosures simply aren't actionably misleading based on the warning of risks that already came to pass. Now, Facebook caveats that risk disclosures can be misleading in other ways. To use its example, if a company discloses the risk that its data protection software may result in third parties obtaining protected data, that could be misleading if the company actually does not have any data protection software at all. But disclosing data security as a risk when a data breach has already occurred or any other similar forward-looking risk about an event that has transpired already simply cannot be actionable under Rule 10b-5. The Supreme Court does appreciate predictable rules that do not depend on how a judge, often acting years after the events at issue, analyzes many competing factors. This can, of course, lead to unpredictable liability for defendants.
Amalgamated Bank argues that its position is in line with a different principle the Supreme Court favors, the text of the relevant law. Amalgamated Bank acknowledges that it is not offering a bright line rule. In fact, although it argues ardently that Facebook is wrong in contending risk disclosures can never mislead investors about past events, Amalgamated Bank does not offer a detailed roadmap about when, in its view, risk disclosures mislead investors about past events. But it essentially asserts that this lack of precision is only natural, and it comes directly from the word misleading. Whether a statement is misleading unavoidably depends on the facts and context, according to Amalgamated Bank. The parties' briefs are also filled with colorful hypotheticals, trying to tease out particular examples of when a risk disclosure might be misleading. What did you think of those, Jeff?
Julia, as is a common strategy in the Supreme Court, the parties appeal to hypothetical examples where they think human intuition favors their side's outcome. Facebook offers examples of risk disclosures intended to strike a reader as not misleading, even if the relevant risk has already come to pass. An Amalgamated Bank does the opposite. For instance, Facebook quotes a Costco disclosure that disruptions due to fires, tornadoes, hurricanes, earthquakes, pandemics, or other extreme weather conditions or catastrophic events may result in delays in production and delivery. It argues that no investor would understand this disclosure as a representation that no such delays had occurred previously. That's a persuasive point, at least from my point of view.
Jeff, I agree. But for Amalgamated Bank's part, it offers a few examples which it thinks might provoke the opposite reaction. For instance, it posits that a company's disclosure of the risk of fire at its factory would be misleading if in fact the company's factory had burned to the ground the week before. But this one doesn't actually convince me. It strikes me as akin to Facebook's data protection software example, where a statement about risks from data protection software can be misleading if no such software exists, but not because risks related to that software have already come to pass. Similarly, a company that discloses a risk of fire at its factory may be making a misleading disclosure if in fact it has no factory at all. So if Amalgamated Bank's posited example is misleading, it may be because the hypothetical company no longer has a factory in the first place, not because the reason it no longer has a factory is that the particular risk it is warning of already came to pass. To take this one step further, if the company disclosed the risk of a flood at its factory the week after a fire burned the factory down, that could be misleading. There is no risk of flood at the factory if there is no factory. But that conclusion has nothing to do with whether or not a flood has already occurred. It's about the representation that there is in fact still a factory. Amalgamated Bank has many other examples though, and I expect the justices will be interested in thinking through them and others that they come up with during oral argument. Jeff, what do you think about Facebook's arguments about the negative consequences of Amalgamated Bank's position, including encouraging substantial litigation and overly disclosing risks in a way that ultimately renders the disclosures less helpful to investors?
I think Facebook makes some persuasive points, Julia, but the Supreme Court recently has not been particularly interested in policy consequences as a decisive factor in its interpretation of statutes. The court views its job as interpreting the statutes that Congress has passed and the lawful regulations that agencies have promulgated to implement those statutes, even if doing so leads to consequences that could be undesirable. So if the court determines that Facebook should win this case, and I think it should, it may discuss these concerns about consequences in a supporting role, or else use these consequences to explain why the Exchange Act and Rule 10b-5 don't intend to impose the liability that Amalgamated Bank is seeking. But I doubt that concerns about maintaining the usefulness of risk disclosures will drive the court's decision in the first place, Julia.
That makes sense, Jeff. I'll be sure to be on the lookout for what the Supreme Court says about some of these second-order consequences, especially if Facebook wins. But I won't expect them to play a starring role. One other advantage Facebook has, including in articulating some of these consequences-driven arguments, is a Supreme Court decision from just a few months ago in the Macquarie Infrastructure Corporation case. In that case, the Supreme Court reiterated that Rule 10b-5 does not impose an affirmative disclosure obligation, so an omission is actionable only if it renders an affirmative statement misleading. A so-called pure omission is not actionable under the federal securities laws. Facebook argues that Amalgamated Bank is essentially trying to undo Macquarie, turning every pure omission of historical fact into a hook to argue that the omission was misleading in light of a risk disclosure, thus proliferating exactly the type of pure omission litigation the Supreme Court said was unauthorized.
Absolutely, Julia. And Macquarie was a unanimous decision that, as you note, is just a few months old. If Facebook can convince the court that its position merely follows from Macquarie, that could be very useful to its case. Any final thoughts, Julia, including regarding when we can expect to receive a decision from the court?
Of course, Jeff. The Supreme Court is expected to decide the case during its current term, which typically ends in late June. So I think we should expect a result by June 2025. That said, the case is being argued early in the term, so it's certainly possible that the court will decide it well before then. We'll just have to stay tuned.
Well, thank you, Julia. And I will look forward to hearing your thoughts on the Supreme Court's decision when it's released. That's all we have for today, everyone. Thank you for joining Julia and me for this installment of S&C's Critical Insights. For more information about our practice, you can visit us at www.solcrom.com.